I can no longer remember anything about my 13th birthday, which I assume I celebrated in some now unrecallable fashion on the third Saturday in May of 1954. But I vividly remember what happened the following Monday. I was stumbling unfocused through the 7th grade at Myers Park Junior High School, and it was just past midday when a knock on the classroom door roused me from my usual post-lunch slumber. The assistant principal, standing just outside the classroom door, carried on a whispered conversation with our 4th grade teacher. At conversation's end, our teacher closed the door and turned in my mind's remembered eye, always in slow motion, and faced the class. And I think our chatter dropped to a hush because my remembered version of this is how serious was the expression on our 7th period teacher. And I believe I can remember well over half a century later my teacher's exact words. "Children, the Supreme Court has spoken. Next year, you will go to school with colored children." I remember the shock of that moment. And of course, as we all know from our era, my teacher's assumption turned out to be woefully incorrect. I finished high school without ever attending class with an African American child. Indeed, had been to the University of North Carolina, to law school, and was teaching Brown versus the Board of Education back at the University of Mississippi, where I was teaching political and civil rights before the first real integration of the rural South of the public schools took effect. So that it's easy to say about the court's seminal decision in Brown, which I think hung over so much of our time at Chapel Hill, it's easy to say that it was without significance because for a decade, nothing happened, many academic scholars say. There was no desegregation from 1954 to well into the 1960s. So that it's easy to say that virtually nothing happened. But nonetheless, I think that Brown was the defining moment of our 20th century political, social, and moral history. Brown did not terminate the Southern racial regime, but what it did was to put a proposition to the American people that racial subjugation was immoral and unconstitutional. Putting this question to the American people was an act of extraordinary boldness, one which put the court as an institution itself deeply at risk. And during those years, 59 to 63, I think we did not know whether the court's boldest pronouncement in a century would in fact go unabided by. We did not know what the outcome would be. But by putting it as a question, and many of you may have had this experience that white Southerners had, African American Southerners had a very different experience. White Southerners were often asked, if you leave the state, what did you think of segregation when you were growing up? Did you think it was right or wrong? I think for white Southerners of our generation, that question didn't compute when we first heard it. To ask whether it was right or wrong was made as much sense or as little sense as asking whether you thought it was right or wrong that the sun came out during the day and the moon at night. It wasn't a normative question. It was simply a fact about the universe in which we lived. At least that was the limit of our perception at the time. Brown changed that by turning it inevitably into a moral question. What did one think about this, and what should you do about what your conclusion was? And it helped embolden what was truly, in fact, an indigenous movement by African Americans in the South that swept through the South as the sit-ins began during our time here, and swept through the South, swept through Atlanta, swept through Charlotte, swept through Wilmington, jammed the jails in Raleigh and Durham, because I think the court's pronouncement made this a moral question and indeed led to action in the political arena, for example, by the by the Congress. And what was extraordinary is the degree to which in 1964, when the Civil Rights Act's public accommodation was passed, there was compliance almost universally on July 1st, 1964, an extraordinary event in the South. There were Dixie grills that turned themselves into private clubs. There was litigation around the edges. But the fact that it had to be done eventually through the democratic political process, that a Senate filibuster had to be overcome, that you had to have an extraordinary bipartisan agreement, as many Republicans as Democrats voted for the Civil Rights Act of 1964 and the Voting Rights Act of 1965, led by the Republican leader, Everett McKinley Dirksen of Illinois. It took that national consensus, and because of that consensus, I think through the political process, we saw far greater compliance with the Civil Rights Act of 1964 and the Voting Rights Act of 1965 than we had with decisions of the court. The court knew that it was pushing the envelope. And I think the court has never been as far out ahead of public opinion as it was on May 17th, 1954. But even then, the court doctrinally, Brown was no big step. It took no radical analysis to conclude that the Southern system of racial apartheid offended a constitutional guarantee that no state shall deprive persons of equality. But what it took was an act of courage. The court understood and made clear as early as 1938 that it was on the road to Brown doctrinally. But it needed World War II. And since the liberalizing effect of sending so much of America overseas and fighting a war against racism and oppression and inequality and intolerance was the way we told ourselves a story about what we were doing in Europe and Asia. Coming off of that, that was a major element of changing America's consciousness. Secondly, I think it took, rolling out of that, Jackie Robinson played an enormous role. That he became what people thought of when they imagined, when white Americans thought of someone of another race, they had someone to think of and they thought of Jackie Robinson. So when he joined the Brooklyn Dodgers in the late 1940s, that too was a major step. And for Earl Warren, who had been the most successful Republican governor in the 20th century as governor of California, Earl Warren, who Eisenhower appointed as Chief Justice, Earl Warren, who had been the Republican vice presidential nominee in 1948 on the ticket expected to win, was thought of as a future Republican presidential candidate. When Earl Warren arrived at the court in 1953, he came upon a court divided 4-4 on what to do about whether they should overrule segregation. The case had been argued in 53, and the court put it over because they were nervous about taking the steps, and there were only 4 of the 9 justices committed to overruling separate but equal. Warren arrived, and he said, "I am the 5th vote. This is done. Now let's make it unanimous." And he spent the ensuing months between the summer of 1953 and May of 1954 taking one justice at a time to persuade them to join a unanimous opinion in Brown. What Warren understood, and part of his motivation really had to do with America's role in the world. Coming out of World War II, we were going to be the leaders of the free world. Europe was decimated. Japan was decimated. Russia was on the brink. But we had to assume world leadership and soon realized it would be in competition with the Soviet Union. And this was an enormous burden that we were carrying in trying to assert world leadership in a multiracial world with a segregated South. Warren thought it essential to America's leadership in the post-war world to end the burden of segregation and what it meant to America's potential for leadership. And so he pulled off that extraordinary effort. But as I said, during our time, no one knew whether it was going to be successful or not in the years 1959 to 1963. The court was tentative about all deliberate speed. It did not undertake to try to rule as a constitutional matter that state-licensed restaurants and hotels and motels were constitutionally forbidden to forbid service on the grounds of race. It played that around the edges. It found very narrow doctrines to overturn criminal convictions of those arrested in sit-ins. It stood back to let the political process work its way through the tumultuous events in the South that led to the passage of those acts. I think it did not invalidate significant acts of the National Congress. It did make a bold reapportionment decision, but in Earl Warren's view, that wasn't the court overruling the democratic process. It was the court facilitating the democratic process and making it work by having fair apportionment so that rural counties didn't dominate beyond their numbers. To show you how unliberal the court was, in the midst of our time here, in November of 1961, near the time that I tried to persuade Beth Walker to run for president of the student body, unsuccessfully, I was unsuccessful in persuading the women of Carolina to do anything in my years. I was O for Chapel Hill. Okay, the court decided a case called Hoyt versus Florida, where the criminal defendant objected to the fact that only men, effectively only men, were called for jury service in the state of Florida. Women could sign up by going to the county clerk's office and going through an elaborate procedure, but only 10 women were included in a new jury pool of 3,000 people, and only men were automatically on the jury. And the court found no problem with that. Perfectly reasonable assumption on the part of the state that women will have conflicting responsibilities and shouldn't be doing jury service, and unanimously upheld the exclusion of women from the jury in a case in which the defendant was a woman charged with murdering her husband. And the issue for the jury was whether there was sufficient mitigation to avoid a second-degree homicide conviction. And her defense was abuse in the marriage. And the court had no problem having that tried before a systematically all-male jury in 1961, which shows, I think, that the Warren court was not yet liberal. Now, what is the role of the court today? I think the court today is much more vigorous, much more muscular, much more willing to substitute its judgment for that of other branches of government, for better or for worse. Partly, ironically, it's because the justices in 1954 were the biographical mirror images of the present court. The court in 1954, on May 17th, was made up of 9 justices, every single one of whom had played a prominent role in American public life before going on the court. There were 3 former United States senators, 3 former attorneys general, the chief prosecutor at Nuremberg, the founding chairman of the Securities and Exchange Commission, and 1 professor, Felix Frankfurter, but when he wasn't grading blue books, he was telling Franklin Roosevelt how and when to enter the World War II. It was one of the most prominent and influential people. The court today has not and of course it had the most popular governor of California. The court today has not a single member who played a prominent role in public life. They all were the Warren court, no one had been a judge. And it was a court that lacked an element. It was willing to make large judgments, but it needed technical lawyering. And when Eisenhower named a very distinguished lawyer, John Marshall Harlan, it improved that court. But it was a court of politicians. The present court is a court of law professors, basically. Really without even litigation experience. But principally, it's a court without anyone who served in elective office. And I think that has made this court very, I don't want to say contemptuous of Congress, though that seems to be the right word at this moment, but I don't. The court today is unwilling to defer to other branches of government. Now, every one of us will have different views depending on what the case is about whether it's a good thing or a bad thing. I know what passions the present court invokes. You should see my emails. Within a single sitting of the court, I argued two cases. One was I argued for the District of Columbia in the case of whether the Second Amendment creates an individual gun ownership right that invalidates the District of Columbia's ban on the use of handguns inside the possession of handguns inside the District of Columbia. And I argued for Exxon in terms of whether $5 billion in punitive damages was excessive for the Exxon Valdez oil spill. And every day I got hate mail, and I tried to guess whether it was from green people on the left who were screaming at me about representing Exxon or gun folks on the right who were screaming at me about representing the District of Columbia. But I was seeing from both sides. I tried often to guess when I won't even quote some of the subject lines of these cases, but I tried to, it was impossible to guess which side these happy congratulatory emails were coming from during that time. But that experience did sensitize me to the degree to which these are matters of great passion. And I actually, in the Exxon Valdez case, when the court granted review, we found out that Justice Alito was recused because he owned stock in Exxon, which meant there was no way to overturn any of this punitive damage judgment without convincing one of the four liberals that it was excessive. And that actually was very bad for my client, but a lot more fun for me, because there was no way to cut a penny of this without persuading either Souter, Stevens, Ginsburg, or Breyer that the amount was excessive. But I love Justice Souter, and he was my target because he thought anything with billions was going to be excessive. He had that kind of New England frugality to him that thought to give the company $5 billion and the attorneys $1 billion was excessive, and on top of the $3.5 million they had already paid. But you know, when I think about the role of the court, the one other case that I would mention that makes me reflect on the court's role in judicial review is Clinton against Jones. You may recall that President Clinton, when he was governor of Arkansas, was involved in an incident in a hotel with a clerk named Paula Jones. And she later brought suit while he was president, a tort suit against the president for damages. And that this was to go to trial during his term as president. The president had his own private lawyers, and they argued that any litigation against a president should be postponed until the end of his term in office, with the plaintiff protected by having any limitations, time limitations period extended, et cetera. So as not to distract the head of the executive branch. And I argued for the United States, and we supported the proposition that any litigation against the president should be postponed. I knew it was going to be a tough sell for the court. I remember Justice Scalia saying, presidents take vacations. Why can't he have his deposition taken while he's on vacation? And fortunately, one of my assistants had come up with a great quote from Ronald Reagan saying, presidents don't ever have vacations. They just have a change of scenery. But this wasn't persuading Justice Scalia. So while awaiting the decision in Clinton against Jones, which I assume would come down in the end of June when the big cases all come down, I argued the case involving the line item veto at the beginning of June. And right before I was getting up to argue, the Chief Justice announced that there was an opinion that day. He said, Mr. Justice Stevens has the opinion in number 96-1201, William Jefferson Clinton versus Paula Corbin Jones. Well, there was this hush in the courtroom, and because it was the line item veto being argued, we had 3 former secretaries of the Treasury, we had 3 former White House counsels, were all there to hear the line item veto, the director of OMB, to hear the line item veto argument. And so I'm thinking, oh my God, I've got to hear the outcome of this case and then immediately stand up and argue another case. And the justices, when they announce an opinion, like to build up to the conclusion and leave you in suspense. But often you can tell from the first sentence. For example, in a criminal case, if the opinion writer begins by saying, from the time of the Magna Carta, you know this criminal defense is in great shape. You know, this thing is going to be flipped. If, on the other hand, the opinion writer begins by saying, it was a dark and stormy night when Mary Jones was walking home from her first Holy Communion, you know where this is coming out. There are just different ways of starting. Justice Stevens began his opinion by saying, the case we decide today involves a lawsuit against an individual who happens to be serving as president. And I turned to my deputy and I said, we're dead. Though I used a more Carolina colorful phrase than we're dead. And sure enough, Justice Stevens begins to use the government's argument as his foil, raising each of the points we made in turn and showing how ill-considered it was and how even more foolish it was than the last inept point we had made. And I'm having to sit there with everybody watching me, listening to this opinion be handed down. But I decided to, since I'd lost denial, I'm now into bargaining. I think, well, this Chief Justice Rehnquist must be dissenting because it's such an important case, he would have assigned the opinion to himself, as Chief Justices often do. So I've got the Chief Justice dissenting, so they'll be good. I forgot that the same week I'd argued the line item, the physician-assisted suicide cases, and the Chief Justice had assigned the opinion in that to himself and gave Stevens the opinion in Clinton against Jones. But I'm not thinking that. I'm thinking surely the Chief Justice is going to write a dissent. And that Scalia, who believes in a strong executive and was once head of the Office of Legal Counsel, will join him. Justice Thomas often goes along with that same position that the two of them would take. And Justice Breyer is such a pragmatist. And I'd always had a hard time counting to 5 anyway. So this is going to be an honorable loss. Well, as Stevens is ridiculing my arguments, I am mentally imagining what the Chief Justice dissenting opinion is going to be like. And in my mind, it begins with, for the reasons put forward with such power and eloquence by the Solicitor General, right? And that's how I'm composing it in my head. Finally, mercifully, Stevens desists and announces that the judgment below is affirmed. And the Chief Justice nods at me, which I think is a lovely touch before he starts his dissenting opinion. And he nods at me again and says, General Dellinger, you may proceed. I think, proceed with what? We haven't heard the dissenting opinion yet. Meanwhile, my deputy is pushing me out of my chair to the podium. And I'm standing up there and I realize there is no dissent. I'm thinking 9-0? I lost this case 9-0. I'm looking at Breyer and Stevens and Ginsburg. What has happened here? So, in any event, I thought that I immediately, in starting the next case, was on autopilot and answered the first question by saying, Justice O'Connor, our objection to the suit against the line item veto is both who is bringing it and when it's brought. This answer was a terrible answer because any answer that begins Justice Ginsburg to a question asked by Justice O'Connor is a really, really bad answer. And I felt like the floor had opened beneath me. And everybody is, people are just, there's this stunned silence. I step out of roll and I said, I'd like to apologize to Justice Ginsburg and Justice O'Connor. Can't believe I did this again. And to you, Chief Justice Souter, I said. And that, everybody laughed. So everybody laughed at that, not because it was so terribly funny, but because, they were so relieved that they had a chance to laugh because the tension had been they'd been so embarrassed. And while everybody's laughing, it suddenly occurs to me, the White House is behind us, right? I'm at the Supreme Court. The White House is a few blocks that way. And I'm thinking, the Paula Jones matter is now his problem, not mine, right? My problem is arguing the line item veto case. In the moment, let's go. And it was actually one of the more rewarding arguments that I had. But here's the point. I thought the court's decision was wrong. I thought that the justices, none of whom had been in litigation, didn't understand the drain that it would cause on the president's time and attention. Things were happening with North Korea, of all things, which I couldn't say. And when Justice Stevens said, but the president, it won't distract the president. His lawyers will take care of all this. I'm thinking to myself, last night after midnight, I got a phone call from the command center that the president was telling me he'd read some cases he wanted me to know about. You're talking about not distracting the president. So not only did the case proceed, they took his deposition. He didn't entirely tell the truth. He lied. Okay, let's get it out there. All right. What can I say? In his mind, he didn't quite tell the truth. Other observers think he lied. Whatever. He was impeached. His impeachment trial, caused turmoil. But I had a very interesting experience a few years after Clinton against Jones came down. One of the summer associates in our law firm had spent the preceding year working with a group in Cambodia that was trying to train a rudimentary judiciary for Cambodia. And one of the hardest things was to convince them that they had some level of independence from the government, that they could actually rule against the local officials. And this was a difficult concept. And the student, she told me that there was only one American case that these rudimentary judges had heard of, and it was Clinton against Jones. And they thought it a thing of wonder. And that made me realize that however inconvenient and burdensome such a process must be to the functioning of the executive branch, that is offset by the more difficult it is, the more that makes the point that no one is above the law. And that I was looking at the short-term effect on the functioning of the executive branch. But from the perspective of 20 or 50 or 100 years, the notion that a government clerk can bring the President of the United States into court is a very powerful message. So that I'm not at all sure that the court's decision was wrong. I want to say just a word then. I think this is a court that is willing to make its own judgments about Congress in a way that I think the Warren Court did not, invalidating major acts of Congress, like the campaign finance laws, and showing little deference, whatever the decision. To me, what is stunning is the limited deference shown to Congress by a court, none of whom have served in public life. I mean, the great thing about Justice O'Connor, she was the last member of the court who had ever held elected public office. She had been the Senate Majority Leader in Arizona. She understood the legislative process. She understood the need to make rough accommodations and was more willing to give breathing space to Congress and the President, however rough their outcomes might be, than the more ideological justices who have been professors or judges for most of their careers and have a great deal of certainty about what they think the right answer is. I think the right answers are often hard to come by, and that some level of deference is awfully useful in the court. By empathy, what I mean, and the President Obama was much criticized for saying that he would look for empathy in his judges. But I actually think that what it means is an ability to put yourself in someone else's position and nothing more, and to think about how the law affects someone in a different position, like a woman on trial for murdering her husband. Now, I've seen one, and for example, the court sometimes shows very little sense, in my view. They equated a program in Louisville, a recent program in Louisville that tried to get some racial integration remaining in the Louisville public schools, saying it was exactly like the system of racial Jim Crow in the American South. And I wrote a piece the day after the decision came down that the Chief Justice Roberts, whom I saw the next day when we both spoke at the Fourth Circuit Judicial Conference, it was not happy with, saying that they failed to understand how different that, whatever the right outcome is, and the Louisville program had its flaws, the idea that it's the same thing as the system that children faced every day in the South, of having to travel the entire South. Terry Sanford read a letter from a soldier at Fort Bragg about what it was like to try to drive with his family every summer to visit the grandparents in East Texas. It was like getting ready for a military operation, to take every supply that you might need, to never know that you could eat if you were hungry. It was 2,000 miles to the grandparents' home. But the worst thing the military officer said was mile after mile of passing signs from amusement parks and trying to explain to the children why they couldn't go from Fort Bragg to East Texas. So whatever the right answer was about the programs in the Louisville and Seattle cases, the idea that it was exactly the same was an exercise in logic that was devoid, I think, of a social sense. So I said something probably in the rush to hit the post button, that the opinion, referring to Chief Justice Roberts' opinion, and my first argument was against him, and I've known him for all those years, but I said his opinion reads, it's an exercise in excellent logic that reads as if it was written by the president of the Law Review, but by someone who missed the first lesson taught to preschoolers on Sesame Street, which is, which of these things is not like the others? Okay, now he took some offense at that, but we've made up. Sesame Street, he said. He didn't want to discuss it further. He just said Sesame Street. All right. Now, there's two more matters to discuss. One of them is the importance of the justices being able to see themselves in a situation. I was co-counsel for Antoine Jones in a case term before last called United States versus Jones, where he was convicted on the basis of evidence from a GPS tracker which was surreptitiously placed on the underside of his car. And the question was not whether the law enforcement can use GPS trackers. It was whether they needed to get a warrant or any other kind of judicial process. They did nothing except decide on their own to place a tracker on his car. So for 30 days, the car was registered to his wife. For 30 days, every movement of the car was transmitted every 8 seconds to satellites in geosynchronous orbit and then downloaded to computers where all of that information was available every 8 seconds, 24 hours a day, every movement, with no warrant, no probable cause, nothing. And what is interesting is when I first looked at the case, I thought, well, they can't do that. And then the first time I started looking at the case law, the court's cases have said if you put like a beeper, a simple beeper in a container, you can put it in the trunk of a car. The guy buys the container, and you follow the beeper. No expectation of privacy on a public thoroughfare. No expectation of privacy. So if your neighbor can follow you down the street, you have no expectation of privacy. And this is no different. Well, I mean, it is hugely different. Your neighbor can't put satellites into orbit and track you every 8 seconds. But the precedents appeared to be against us. I would really love to have argued Jones, but his public defender, our deal was that we would do all the brief writing, and the public defender who had represented him would argue in the Supreme Court. But it did mean that I was more free to comment about the case in advance. I usually don't talk about cases in advance if I'm arguing it. But since I wasn't arguing, I felt a little free to talk about it. Oh, that's actually good, because I got some things that I'd be uncomfortable saying in court that the justices might hear. So on the National Public Radio, Nina Totenberg usually does a show for big cases the morning of the argument, called a setup piece. Here's what case is the court's going to hear. So for Jones, when she finished the interview, she said, "Is there anything else you want to say?" And I said, and I knew she'd use this, I said, if the government's submission is accepted by the court, any law enforcement officer in the greater metropolitan area can put a GPS device surreptitiously under any car belonging to any or all of the justices of the Supreme Court for any reason or no reason at all, or just because they want to know where the justices go when they leave the court. And she, I was not surprised that ended her morning story. So at 10 a.m., the government was up first, and the excellent Deputy Solicitor General, Michael Dreeben, begins to say, "May it please the court," and he gets through "may it," and Chief Justice Roberts says, "Just one moment, Mr. Dreeben, before you begin, if we accept the government's submission, does that mean that any law enforcement officer in the greater metropolitan area can place..." And Dreeben tries to avoid it at first by saying, "Well, this court has held that the expectation of privacy on public..." He says, "I take that's a yes?" And Dreeben says, "That's a yes." And I thought, three things. One, we won this case. This is, there is no way the court is going to hold that anybody who wants to, that's a law enforcement officer without any warrant, can put a device under their cars. Secondly, the Chief Justice listens to NPR on his way to the court. And third, that the Deputy Solicitor General does not. He was caught by surprise. But this is an instance, I think, where, we also made, because I wanted to appeal to the conservatives on the court, a property-based argument as well as a privacy argument, that it was his car. They were commandeering his own car. And that was the sort of argument that would appeal to Justice Scalia. And we made that very forcefully. So we got a unanimous decision. Some based on a privacy rationale, some based on it was his property. They have no business commandeering his property. But we won a unanimous court in that. And I think it does show the importance of the justices being able to proceed. All right, let me end by this, just last words on this term. The court is likely to strike down the Voting Rights Act because it thinks Congress should have redone the formula. And it's going to be an example to me of an approach the court takes. They're asking the question, do they believe the Voting Rights Act is still necessary? Do we, the justices, believe the Voting Rights Act is still necessary? And do we believe that using the old coverage formula instead of redoing the formula about which jurisdictions are coverage makes sense? Rather than asking, was Congress acting within a permissible zone whether you agree or disagree when it made the contrary decisions? I mean, it is almost completely in the questions, the way they formulate it, completely conflated whether they think it's a good idea and whether they think Congress can constitutionally come to that conclusion. This term, so I think the Voting Rights Act is on the chopping block. There's some boring, what is more boring than domestic relations law? There's some family law case. Oh yeah, gay marriage. I knew I would think of it if I waited long enough. Gay marriage is before the court. There are two cases. I should acknowledge that I've been involved in different ways in each of them. The Defense of Marriage Act case is the one I have more confidence in the outcome. The federal defense of marriage law, I think, is going to be struck down by the court because in that case, gay rights and states' rights are on the same side. What happened was this. There are 1,000 federal statutes that refer to spouses in terms of, it's rife throughout the Internal Revenue Code, the Social Security laws. You'd be amazed at how the military burials, family members, spouses. So what is a spouse for federal law? Congress never adopted its own definition of who could be a spouse, but it relied upon what each state did. So if your marriage was recognized in the state in which you lived, that was good enough for the federal government for all purposes. The Defense of Marriage Act, which was passed when it was first thought that Hawaii might allow gays to marry, overrides that and says even if your state has decided to marry you and to license your marriage, the federal government won't recognize it for any purpose. So for justices that like states' rights, they're offended by the intrusion of Congress into what a state wants to do. You always like to have a good plaintiff when you're bringing a big case. Somebody's got an appealing case, and the Defense of Marriage Act could not have a better central casting plaintiff for those who are seeking to invalidate the law that doesn't recognize the gay marriages. Edith Windsor had a 30-year partner, another woman. They were married in Canada, returned to New York. They're duly married in New York, which has dropped its opposite sex limitation on marriage. Edie Windsor's partner died and left a fairly substantial estate to her. And as you know, I think we're all getting into the estate planning years. You don't have to pay estate and gift tax upon death when your estate passes to your spouse, because there's a common economic unit. And if you ever wonder how do you decide who's a spouse for that purposes, do you have a license from the state that says you're married? And of course, Edith Windsor has her marriage license, and the state of New York recognizes her marriage. The Defense of Marriage Act clearly overrides that and says she has to pay $360,000 because the federal government won't recognize New York's decision to allow her to marry. And I think the court is going to find there are a number of ways to decide it, some on more narrow grounds, but I think the court is going to say Congress just has no business deciding what state family law ought to be. And if the state of New York has made this decision, then the federal government ought to treat that, for tax purposes. And I think that will be a major victory. It's hard to overstate that. I think people have understated the importance of the Defense of Marriage Act, because right now in this country, even though there are 11 states that recognize gay marriages, no one is really married in any of those states because there are 1,000 federal purposes for which you're not married. So no matter what the blue states do, they're not really successful as long as Congress says, we're not going to treat you as married for 1,000 purposes. Now, a bigger swing is the California case, Prop 8, the case brought by Ted Olson and David Boyce. There was a lot of behind-the-scenes controversy among major gay and lesbian organizations over whether this was the right time to bring a case arguing that there's a constitutional right to gay marriage, with many in organizations believing that this was precipitous, it was too early, the political movement is in the right direction, and a Supreme Court decision holding that it's perfectly constitutional to deny gay marriage would be a big setback. It's best not to risk that when politics is moving as rapidly as it is. Ted Olson and I speak to the state attorneys general every year, and I raise this with him. I said, what do you say? Here's the criticism, including a veiled reference in Justice Souter's last opinion about the need to go slow and give people a time to accommodate to new ways of thinking. What's your response? And Ted Olson talked about his clients and said that one pair of his clients, the Perrys, had children in high school, and their children had told him, we want our parents to be married in time for our high school graduation. And Ted said, I can't look at my clients and tell them we should wait. We should wait. We should bring this case some years from now. Very interesting how powerful an advocate he is, because half the AGs are red state AGs, and they were very moved. I can't give you Ted's whole argument, but he has been very effective as the winning counsel in Bush versus Gore in carrying this issue because people will listen to him. But I think if you think about it, there were 13 states that still had segregation at the time, de jure segregation at the time of Brown. There were 13 states that still criminalized homosexual acts at the time of Lawrence against Texas in 2003. So it's one thing for the court to sort of finish off the game board of the last 13 states. Another thing to take on the law of 39 states. And I think the court's very concerned about the Southeastern Conference, basically, what happens in Georgia and Alabama and Mississippi if the court made a constitutional ruling. So I think it's very risky. I think the doctrinal, because the court held in Lawrence against Texas that moral disapproval was not a legitimate grounds for governmental action in this area, that left the supporters of the restriction with very little to argue. Even able advocates, I thought, were at a loss to come up with a coherent argument, but I think the court is hesitant. I filed a brief. I think the gay marriage case was over when the California state officials failed to appeal from the trial judge's ruling and filed a brief arguing that there was no standing and the court should simply not rule in the gay marriage case and leave the case standing, which would apply to those couples and 2 county clerks and maybe would be applied more generally in California. But if I'm right that there's not really a real case or controversy because the state of California is not resisting, and just generalized opponents of gay marriage who supported the referendum that ended gay marriage have brought the case, I think the court may hold that it's over. And it appeared that there was a lot of support for that proposition at oral argument to leave this for the political process. So when I think about the cases, you either like the campaign finance decision or the gun decision. You probably don't like both, or you don't like either, but I mean, I think we all have different views on what the court did. It radically transformed the Constitution in the Dred Scott decision in a way I think was a false reading of a slavery-centered Constitution. We all have our list of cases we think were terribly wrong, and some we love and clasp to our bosom. So when I think about, and I'll just end with this, the question of whether on balance active judicial review has been a good thing or a bad thing. I think my answer at this point would be the answer given by the Premier of China, Zhou Enlai. He was quite an intellectual, educated in France, and he was asked by a French journalist what was his opinion of the effect of the French Revolution. And he answered the way I would answer the question about judicial review. It's too early to tell. Thank you. You want to take some questions? Want me to take these questions? Okay. That's 1 or 2 questions, and then there's going to be an announcement about taking your pictures. Everybody try to look 10 years younger. Yes, sir. Bob?
Obamacare decision. What's your opinion?
Well, the question was Obamacare. And, people don't have strong feelings about it. So I'm happy to discuss it. No, I was very actively involved because I debated on behalf of Obamacare against my friends who brought the lawsuits, Paul Clement and libertarian professor Randy Barnett. I thought it was an enormous tempest in a teapot in the following sense, that the requirement that people have health insurance, which was the principle that was issued, can you require people to eat broccoli? I always thought, and indeed this is pretty much where Chief Justice Roberts came out, could simply be said to be, look, it's just a modest additional tax that you have to pay if you choose not to have comprehensive health insurance. And that, Governor, this was always the conservative approach. It was Governor Romney's approach. Let the free market work, but provide some incentive. So in my view, when you enter the workforce and take a job in national commerce, you leave your hut in the woods, you go into national commerce, you get a job, you have income tax, taxable income. They tell you 3 things. 1, we're going to take out, you have to pay 7.5% for Social Security for your old age subsistence. You have to pay another percentage for Medicare for your old age health care. And now, if you don't have adequate health insurance, you have to pay a 2.5% surcharge on your tax. At most. It's $95 in 2014. Never to exceed 2.5%. Who is going to say, well, these first two are fine, but the third one is the end of liberty as we know it in the Western world? So in fact, actually, the conservatives who led the attack on Obamacare, that's why I always thought, what is this lawsuit? But they actually won a lot. I think in some sense it's true that the individual mandate was invalidated. Chief Justice Roberts joined the other four in saying you can't constitutionally require people to buy insurance, but he read the tax the way the government had said, finally, in its reply brief, the government made the argument that you don't have to have insurance if you don't want to. It's a choice. You're not a lawbreaker. It doesn't quite read that way, but before striking down something that regulates 1/6 of the national economy, the court ought to defer to Congress by saying, we read this that if you don't want to have health insurance, fine, but you have to pay an additional 2.5%, and that there's nothing sort of dramatic about that. So I thought that it was, what led Chief Justice Roberts to do that, other than, in my view, it's the right answer. I think, the court was going to own the healthcare system. Our healthcare system is probably going to be a disaster with or without Obamacare. And we would, never again in 40 years get a national healthcare solution. So whatever was happening in the healthcare system, the Supreme Court was going to own it. And they were going to be, blamed by 5-4 for having brought this down and left nothing in its place except a system that's not working because we have emergency rooms as a provider of first resort, et cetera, et cetera. We have terrible consequences of the existing system. So I think it was, I think the court stepped back from the brink, but I think, and there's a lot of antipathy in Washington and among my conservative friends towards Chief Justice Roberts. But I think he thought this was a bridge too far for the court as an institution. He's going to be there a long time. He's very conservative. He's very smart. He's very young to be Chief Justice. And he was, in my view, the single best advocate before the Supreme Court. I thought he was the best. And that's quite an extraordinary skill set to bring to the Chief Justiceship. No other Chief Justice has come as a great Supreme Court advocate. So what he was good at was persuading 5 justices to agree with his client's position. And I think in the long haul, that skill is going to make him very influential. He's playing a long game. Obamacare might have seemed big at the moment, but he's thinking of a 40-year Chief Justiceship long after the class of '63 has come and gone. One more question, and then we can, yes?
The campaign finance law, Citizens United, your opinions on that?
Well, I think it's a genuinely hard case in the sense that I do think that restrictions on political expenditures raise First Amendment problems. And that one of the problems with regulating campaign finance is that ultimately, how do you stop short of the New York Times editorial page? I mean, a family owns the New York Times and they work very hard supporting their candidates. They're usually the candidates I support. But still, as a matter of, a lot of money goes into supporting political candidates when you buy your own newspaper. It's just very hard to draw those lines. Now, I think, in my view, they should have shown more deference to Congress, but I think it's a genuinely hard case. I think disclosure is so important, though, that we've lost the chance to have disclosure. We don't know who Mothers for Apple Pie or Americans for Wholesome Government are. Who are these people? And you don't know what their agenda is. You don't know who they are. It could be the People's Republic of China's sovereign wealth fund that is this nice couple sitting at their kitchen table that is paying for these ads without, disclosure. So I think that's quite important. I'll just close with this. I remember one moment walking last night down Franklin Street past the Varsity Theater and and the Carolina Theater. My picket line assignment was one night a week. My sign had some really embarrassingly a slogan on it, but I was picketing the movie theaters, and we had made an arrangement with the city that we wouldn't disrupt entrance or egress to either of the movie theaters. They were not segregated, you may recall. Only whites were allowed to attend the movie theaters. But we always had a plan to have 2 white and 2 black pickets at the same time. But the schedule didn't always work out. And one night, I was picketing with 3 African Americans, and we circled around. And an older gentleman of the town stopped and watched and stood there for a good while as we circled around and around. And on my 3rd pass through, he said to me, he said, "Son," says, "I don't know about the other 3, but you could pass." And to this day, I don't know whether he was being sarcastic or